Good evening. Thank you for joining us for Crafting Your Legacy with Estate Planning and Trusts. I'm Todd Holden, one of the advisors here at Northwest Financial Advisors, and I am joined today by Kathleen Miller, Vice President and Senior Trust Officer with Members Trust Company. Before we get started, please allow me to read a few disclosures to you for your awareness. The information contained in this presentation is for educational purposes only and not intended to be a substitute for specific, individualized advice. We recommend that you consult with your financial advisor for guidance specific to your unique situation. Please be advised that this presentation is being recorded for the purpose of sharing content after the webinar. All attendee questions will be removed from the final recording. Northwest Financial Advisors is a subsidiary of Northwest Capital Management, which is a wholly owned subsidiary of Northwest Federal Credit Union. We have been providing holistic financial planning advice and solutions for over 25 years. Your life is at the center of everything we do. This chart shows a lot of the issues or a lot of the topics we cover, and tonight we're going to be covering the purple one, estate planning. Northwest Capital Management, Northwest Financial Advisors, and LPL Financial are not affiliated. Kathleen?
Members Trust Company is a company that was founded in 1987 by America's credit unions. We have Main Street values and we have Wall Street expertise without the ego or the high fees. Industry recognized innovators and subject matter experts in trust and investment solutions, big and small. An estate plan is the mechanism or mechanisms you put into place to transfer your assets to your intended beneficiaries. These mechanisms could take effect at your death or to some degree when you're alive, meaning during your incapacity.
How do assets transfer? Generally, there are 6 ways that assets transfer ownership. Gifts to beneficiaries or charities while you're still alive, joint ownership with right of survivorship, JTWROS. You might also see this just abbreviated as Joint 10, JTTEN, beneficiary designations, wills, trusts, and transfer on death deeds. Let's talk about gifts. Gifts made during your lifetime can be given to either people or charity, intended for either income tax considerations or to keep estate tax below a certain level to avoid estate tax at death. Currently, the federal estate tax exemption for 2022 is $12.06 million. That will sunset in 2026, where it'll go to about half of that, and estate taxes vary by state. Joint ownership. The pitfall, 2 people can own assets together, and either of those 2 people can transact business in that account. When one person dies, the other inherits the entire asset. Common pitfalls. The most common pitfalls of joint ownership is that the surviving owner is ill-equipped to manage money, or a parent puts one child on all of their accounts and expects that that child will make it right by sharing with their siblings. Quite often, this is prone to failure. Beneficiary designations are used for retirement accounts such as TSP, Thrift Savings Plan, 401k, IRAs, etc. Can be used for non-retirement accounts through payable on death. You'll generally hear that term at financial institutions, or transfer on death designations, which is what we use in the investment industry. Beneficiaries have no ownership in the account when you are living, but they get the money at death without that account going through probate. They bypass the probate system with a beneficiary designation.
A will is a legal document, usually prepared by an attorney. It names an executor who disperses your assets per terms of the will. It involves the court system and goes through probate. The next slide will explain what the probate process is. Probate refers to the action of submitting the will to the clerk of the appropriate circuit court or to the court itself and proving with appropriate documentation or testimony from witnesses that the will is valid. The term probate is also used to refer to the general process of administering an estate. It can be very time-consuming. There is a probate fee which varies by state, and the probate process is public record. Trusts are not always one size fits all. There's different trusts used for different goals. Common trusts that you probably heard of include revocable living trusts, special needs trust, qualified terminal interest property trusts, also called QTIP trusts, charitable remainder trusts, and all trusts have common features. A grantor is the person or persons who establish and fund the trust. Trustees are the people or organization who control the trust. Often this will be the grantors. Successor trustees are the people who will take over control when the original trustee can no longer manage the trust. Usually the successor trustee takes over when the original trustee becomes incapacitated or passes away. Beneficiaries who benefit from the trust. This can be the grantors or others named in the trust.
Next, we'll talk about the most common types of trusts and the scenarios they address. A revocable living trust is a legal document that sets forth the way in which you want your assets to be distributed upon your death. It is established during your lifetime, typically to avoid probate and to exercise post-death control over trust assets. Since a revocable living trust is revocable, can be altered or canceled, you can change it as your circumstance or wishes change. Upon your death, you basically replace the public and sometimes lengthy probate process with a private administration of your estate. Instead of a personal representative or executor shepherding the administration of your estate through the probate court, you designate a trustee to step into your shoes and essentially accomplish the same type of things: marshaling assets, appraising assets, paying debts, but all done in a private setting. And in the event of incapacity, you can avoid conservatorship proceedings since your backup trustee can step into your shoes and manage the trust assets for your benefit while you're still alive. No court involvement, and since there is no court involvement, the terms of your trust do not become a matter of public record. Privacy is maintained. Furthermore, living trusts are like a Swiss Army knife in that they can be customized to address your specific goals and circumstances.
Special needs trusts are established for people who you anticipate will never be able to take care of their own finances. These are designed to make certain the beneficiary that you are leaving an inheritance to does not lose benefits from government programs for which they may qualify or are currently receiving. It is very important to use an elder law attorney who are experts in this field of law.
Qualified terminal interest property trust. Often they're used in second marriages when one spouse wants to provide an income for another spouse, but he or she wants the assets to go to the children from their previous relationship. One way to provide for all loved ones is to place some assets in a trust that the surviving spouse can use during his or her lifetime. Then when the survivor passes away, everything left in that trust goes to the children from a former relationship. Since the balance is earmarked, a surviving spouse cannot prevent the trustee from transferring assets to the intended ultimate beneficiaries. Often we hear things such as, "My spouse and I have a wonderful marriage, but I don't want any of my money going to their deadbeat children." A Q-tip trust or Q-tip prevents this. Charitable remainder trust. These come in many different forms. Generally, they are meant to provide for some type of benefit to a person, a trust beneficiary, for a period of time or even that person's lifetime. At the end of that time, the remainder of the trust will go to a charity. I think we're going to hear more and more about these as people with large retirement accounts, TSP, 401ks, IRAs, use charitable remainder trusts to get around some of the onerous distribution requirements that were created by the Secure Act in 2020. As more people with large IRAs and retirement accounts realize what's going to happen to these accounts when they try to pass them to children, I think that they'll determine charitable remainder trusts are a good way to provide for the children and then leave some money for charity as well. Choose wisely when selecting a trustee.
The trustee acts as the legal owner of trust assets and is responsible for handling any of the assets held in trust, tax filings for the trust, and distributing the assets according to the terms of the trust. Both roles involve duties that are legally required. Trustees are trusted to make decisions in the beneficiary's best interests and often have a fiduciary responsibility, meaning they act in the best interests of the trust beneficiaries to manage their assets. Your options for a trustee could be a loved one, an institution, or an institution and a loved one, and it's called a co-trustee relationship. When you name a loved one as a trustee, will your grieving loved one have the emotional wherewithal to take on the responsibility? Does your loved one have the time and desire to settle your final legal and financial affairs? How will family dynamics be impacted by that decision? Does your loved one live nearby? Having an institution as a trustee allows you to have professional asset management, legal proficiency to administer the terms of the trust. Institutions are regulated entities who have oversight and accountability. They also have the legal duty to act in the client's best interest. The institution has a perpetual appointment, and they have capital and insurance. In a situation where you would like to name an institution and a loved one, you minimize family disputes. Professional management by an institutional trustee coupled with decision-making input from a family member could be the best of both worlds.
And if I may pipe in here, Kathleen, quite often what we see is parents who their inclination is to name a child who is well sorted out and make that child responsible for their sibling who has never quite gotten their life together. And this can damage an already fragile sibling relationship.
Correct. And what's nice is when there's an institution as a trustee, they could be the bearer of possible unwanted answers with regard to trust distributions. So it helps keep a balance of allowing your family members to have a relationship, but allowing the corporate trustee to work with the beneficiaries to give them information that they may not want to hear.
Sure, absolutely. So with your estate planning documents, if you go to an attorney and you say you need to get an estate plan, you're going to get more than just a will and a trust in most cases. So as part of that process, you're probably going to be asked about who would you like as power of attorney, because a trust is run by a trustee, and that they're not your power of attorney. They can be, but they can also be two separate things. You're going to get asked about living will and medical directives. Some attorneys will ask you to designate the person who's going to be responsible for making specific arrangements for your remains at your death. Thank you very much for attending tonight's webinar with Kathleen Miller and myself. Again, I'm Todd Holden. You, as members of Northwest Federal Credit Union, can have a complimentary consultation with myself, Kim Heffernan, or Nikki Young. Any of the three of us would be happy to meet you. There will be a questionnaire at the end here, and you could say we'd like a meeting and you'd like to meet in any of these locations listed. We have branches in all of these locations. Thank you very much for joining us this evening. Very much appreciate your attendance.
Thank you, everyone.